Yesterday, Professor Goldsmith mentioned some of the characteristic aspects of cyber activities, among them the fact that technology has, of course, eliminated distance. Attribution can be very hard, and you cannot safely infer attribution simply from the context. The public-private distinction can be, as he said, muddled, as can the public-private distinction. Public-private distinction can be muddled, as can the distinction between domestic and international. And of course, there is the issue of distinguishing an attack from an instance of exploitation. And finally, there are more potential adversaries, both public and private, because more have been empowered. The bottom line, of course, is that the thresholds and categories important to law are difficult to establish. Our first speaker, Wolff Heìnschel von Heìnegg, a once and future Stockton Professor of International Law, will lead us off. Wolff will speak on sovereignty and neutrality in cyberspace. The question of sovereignty is relevant, of course, as states have a right to exercise control and jurisdiction over cyber activities taking place within their territories. Neutrality is relevant because the belligerent needs to know the threshold for activity that violates the neutrality of another state, and a neutral state needs to know what cyber activities it must prohibit in order to preserve its own claim to neutrality. But is it even possible to prohibit some cyber activities, even assuming the neutral state wishes to? So with that, Wolff, please take it away.
Well, thank you, and good morning, everybody. As already mentioned by our moderator, I will not talk about the law of armed conflict. I will not talk about the use of force, but about sovereignty and, in view of the short time, only shortly about neutrality. And since yesterday we heard some interesting approaches to sovereignty, I have decided to add to the confusion by clarifying some things. First of all, as you may recall, Mike Schmidt reminded us yesterday of the Palmer's arbitration. And let me quote what sovereignty is all about. Sovereignty in the relation between states signifies independence. Independence in regard to a portion of the globe is the right to exercise therein, to the exclusivity of any other states, the functions of a state. That's Palmer's. And if we talk about territorial sovereignty, we may again quote that it implies that subject to applicable customary law, of course, or conventional rules of international law, the respective state alone is entitled to exercise jurisdiction, especially by subjecting objects and persons within its territory to domestic legislation and to enforce these rules. Moreover, the state is entitled to control access to and egress from its territory. And the latter right seems to also apply to all forms of communication, like it or not. And it must be borne in mind that territorial sovereignty does not merely afford protection to states, but it also imposes obligations upon states, especially the obligation to protect within the territory the rights of other states, in particular their right to integrity and inviolability in peace and in war, together with the rights which each state may claim for its national in foreign territory. And those are well-established aspects of sovereignty and the related but not identical concept of jurisdiction. Of course, cyberspace, according to many, escapes an applicability of those traditional principles. They are, of course, pointing at the characteristics of cyberspace: ubiquity, anonymity, network of interdependent networks. And they consider it a res communis, I mean, a global common. There, of course, the analogies to the law of the sea and to the law of outer space come into play. Some even claim that it should be assimilated to a common heritage of mankind. So they are all very nice ideas out there, which have one little deficit. They are ideas. They do not reflect the consensus of states. And what we tend to forget about the novel characteristics or the allegedly novel characteristics of cyberspace, we forget that it requires a physical architecture to exist. And at least the basic layer of what we call cyberspace is very real. So there is no necessity to apply some metaphysical standards. Of course, the technological and technical problems involved do not prevent a state from exercising its sovereignty. So don't forget that. And especially its criminal jurisdiction. So if we look at it in a rather sober manner, I think we can easily say that at least certain aspects of what is called cyberspace are subject to sovereignty and, of course, are subject to the jurisdiction of states. So what are the consequences? The first consequence of this finding is that the cyber infrastructure located in areas covered by the territorial sovereignty is, of course, protected against interference by other states. And this protection is not limited to activities amounting to an unjustified use of force, to an armed attack, or to a prohibited intervention. We, of course, tend to focus on these three aspects. But let me remind you that the protection of sovereignty goes far beyond than just addressing those three forms of violations. And an intervention, let me remind you of that as well, always has to have a coercive element. But there are other forms below use of force, armed attack, and intervention that, of course, without a coercive element, may constitute violations of a state's sovereignty. As regards the cyber infrastructure that is thus protected by the principle of territorial sovereignty, it is irrelevant whether it belongs to or is operated by governmental institutions, private entities, or private individuals. So it's a simple question of territorial sovereignty and/or territorial jurisdiction. The second consequence of the applicability of the principle of territorial sovereignty to cyberspace or to parts of cyberspace is the wide-ranging right of the territorial state to exercise its jurisdiction over cyber infrastructure and over cyber activities occurring in its territory. But it's not only about persons acting on the territory or objects located in the territory of a state that are thus protected. And there is yet another feature that was mentioned yesterday shortly in the discussion, and that is the so-called effects doctrine, according to which a state is entitled to exercise its jurisdiction over a conduct that does not take place within its territory, but that produces effects or harmful effects in that territory. And that is well recognized and well established in international law. So in sum, we can say that one very important aspect of sovereignty and territorial jurisdiction is protection of a state with regard to objects and activities occurring within its territory to the exclusion of any other state. What we should not forget is that it goes along with obligations. And there is, of course, a duty on behalf of every state to terminate the violation of the territorial sovereignty of another state by activities occurring within its territory. The International Court of Justice in the Corfu Channel case has held that respect for the territorial sovereignty of other states implies the obligation of every state not to allow knowingly its territory to be used for acts contrary to the rights of other states. Hence, a state is required under international law to take appropriate acts and steps in order to protect the interests of other states. And this obligation is not limited to criminal acts, but to any activity that inflicts damage or severe damage on the territory of another state. Let me be clear, this is an obligation to terminate a violation of the sovereignty of another state that is occurring. Very often this is labeled a duty of prevention, but it's not a duty of prevention. Secondly, it must be emphasized that this duty to terminate an ongoing violation presupposes knowledge. This does not necessarily mean actual knowledge, so it could also be presumptive or constructive knowledge. Knowledge is to be presumed if a cyber attack, for example, can reasonably be considered to belong to a series of cyber attacks. And it is important, however, to note that the International Court of Justice has held in the Corfu Channel case that even if a state on whose territory an act contrary to international law has occurred may be called upon to give an explanation, it cannot be concluded from the mere fact of the control exercised over its territory that that state necessarily knew or ought to have known of any unlawful act perpetrated therein. So the mere occurrence on the territory is not enough for triggering the obligation to terminate. Under general international law, there is no duty of prevention. There is no obligation to monitor all activities within the territory and to interfere if this may prove necessary. Furthermore, we have to, of course, shortly, and I will not dig into it too deep, shortly talk about the issue of attribution. We heard yesterday a lot about attribution, but there is one aspect I would like to emphasize. Now let's assume we are in a position to identify the source of some malicious cyber activity. And if we are sufficiently certain that this cyber activity has been launched from or originates from the infrastructure belonging to or operated by a government, some would say there would already be a rebuttable presumption that this activity can be attributed to the respective territorial state. Maybe that goes too far. Others would say at least it is a strong piece of evidence. And I think there are good reasons to support that view, and it would well be in accordance with the principles of attribution laid down in the ILC's draft articles on state responsibility, which I will not talk about. Of course, many people seem to be unsatisfied with the law as it stands. They are calling for new rules, new treaties, a modification, an adaptation of the rules. And yes, there may be a necessity of progressively developing certain rules of international law by at least clarifying their scope and their applicability with regard to cyberspace and cyber activities. And I think the best way that has been described is the international strategy for cyberspace by the United States President. He reminds us of 5 criteria that must be taken into consideration when it comes to applying existing rules and, if necessary, progressively developing further rules. And those are reliable access, multi-stakeholder governance, global interoperability, network stability, and finally, cybersecurity due diligence. And I think if we follow on that path, those criteria are what I would say of a potentially norm-creating character if it becomes necessary to really develop the law with a view to the characteristics, the special characteristics of cyberspace. But let me emphasize also that this is nothing you can do on a unilateral basis. You have to find like-minded states, you have to get them on board, And together with them, you have to endeavor in a concerted effort to convince states to follow on that path. The mere fact that you may not like the law, or that the law as it exists, as it stands today, may prove to be an obstacle to what you wish to achieve, is certainly not enough. So you have to get other states, as I said, on board. Otherwise, you will end up in either a violation of the law or you will be a lonely wolf somewhere in the desert. In the remaining time, I would like to shortly talk about neutrality. Now, neutrality is probably one of the most contested branches of international law. Many different positions, especially taken by states. If we want to talk about neutrality at all, this presupposes the existence of an international armed conflict. In a non-international armed conflict, there is no concept of neutrality. Of course, the general rules of international law continue to apply, respect for the territorial sovereignty and all these things. But this is a different issue. It has nothing to do with neutrality. Now, it may be that the scope of applicability of the law of neutrality is far from settled. Many, of course, refer to the Hague Convention number 5 and Hague Convention number 13 on neutrality in land warfare and sea warfare of 1907. And of course, they say, how could the drafters of those old conventions have ever envisaged something like cyberspace? Of course they haven't. But the drafters of old treaties, the many fathers and few mothers of older treaties, have certainly not envisaged many of the technological developments that followed suit. Still, we agree that despite of the revolutionary or allegedly revolutionary character of the technological development, those long-standing treaties continue to apply. So the mere fact that a treaty is of a certain age, more than 100 years, is certainly not an obstacle to its application to certain activities or measures. And let me remind you that the primary object of the law of neutrality is to protect the sovereignty of neutral states and to prevent an escalation of an ongoing international armed conflict. And despite of the unique characteristics of cyberspace, there is widespread agreement that that body of law applies to cyber operations taken against or by use of cyber infrastructure that is located within the territory of a neutral state. And belligerents are under an obligation to respect the inviolability of neutral states, and they are prohibited to exercise belligerent rights within the territory of neutral states. I must admit it is not yet sufficiently clear whether that prohibition also applies to malicious cyber activities transmitted through neutral cyber infrastructure. So there are many analogies, like transporting weapons across the territory of a neutral state would be prohibited, and they are then assimilating weapons with malicious cyber software or cyber codes. I think that goes far too far. Don't forget that it's very often a fortuitous event that the packages are traveling via state A and not via state B. Very often, knowledge is lacking anyhow. Finally, neutral states are, however, prohibited to allow the exercise of belligerent rights within their territory. And moreover, they are under an obligation to take all feasible measures to terminate such exercise. Again, I must admit it is unclear whether neutral states are also obliged to prevent a future exercise of belligerent rights. I am very skeptical whether such a duty of prevention exists at all. And even if we applied some of the ancient rules of 1907 in an analogous manner, it would still be difficult to construct a duty of prevention. The only scenario I can imagine and think of that would trigger a duty of prevention would be the following. A neutral government, is aware of the preparation of malicious cyber software in its territory that will be used against one of the belligerents. If a government has such knowledge, then there may be a duty to prevent such activity or from the malicious software being placed at the disposal of one of the belligerents. But that's a very constructed case, and I cannot imagine any other scenarios that would fit into that. And finally, let me remind you, and that's how I come to the end within the time frame imposed on me. If a neutral state, however, is unwilling or unable to comply with its obligations to terminate a violation of its neutral status, the aggrieved belligerent is entitled to enforce the law of neutrality, subject, of course, to proportionality. This does not mean that the neutral state would become a party to the conflict, but it's just a reaction to a violation, a measure of self-help, more or less, that, of course, the aggrieved belligerent is always entitled to take. Thank you very much.
Thank you very much, Wolff. Our next speaker, Sir Daniel Bethlehem, will discuss the legal framework for analyzing cyber operations with preliminary comments on comparative or comparative advantage, domestic authorization, sources of law, and the end of geography. Secondarily, why we perhaps should be slow to move to a default of a jus in bello analysis, what the elements of a jus in bello inquiry should perhaps be, and Sir Daniel will conclude with the wider international law framework and challenges, specifically sovereignty, jurisdiction, non-intervention, immunities, and state responsibility. Sir Daniel.
Thank you very much indeed. I'm delighted to be here. This is a very important event, and I do commend the organizers. I should say right at the outset that by mistake I picked up the wrong a pair of glasses this morning, so you all look as if you're shrouded by a very rosy hue. I hope that continues into the Q&A. Then I might say something which is in agreement with you. Let me say right at the outset that I agree very much with Wolff's analysis of the Lex Lata. My few remarks are not intended to be descriptive about the law. What I'd like to do is, in fact, make an argument, because it seems to me that we need to go beyond the Lex Lata, and that we also need to recognize that there are important areas of uncertainty when it comes to cyber and the legal framework. So I'm going to shape my remarks around four broad themes. First of all, one or two preliminary comments. Second, around the proposition that, in my view, we should be slow to default to a jus in bello analysis. Third, some possible elements of a jus in bello gateway analysis. And then fourth, one or two observations about the wider framework of general international law. So let me then start off with some preliminary comments. And going back to one or two of the aspects that were picked up in the discussion yesterday, my inclination from the last 5 years of experience that I had in the British Foreign Office seat, which, as I mentioned in one of the observations I made from the floor, was a seat which also looked very closely at our GCHQ and MI6 operations, just by virtue of our statutory arrangements. My inclination is to say that we ought to engage in a rather deeper inquiry of our competitive or comparative advantage position. No doubt we're doing so inside government, but also in the context of discussions like this. It seems to me that probably we still very much do have a competitive advantage because of the creativity of our institutions and our private companies. But for reasons of both quantity and command and direction, I wonder whether we do actually have a comparative advantage when one looks at the sheer volume of hostile cyber activity coming out of China, for example. As was suggested yesterday, I think that our economies are also economies of greater vulnerability. and inevitably we are going to lose our edge, whatever edge that may be. So the first proposition that I'd advance is that this is a time to act, to craft a benign or more benign legal framework, realizing that as time passes, we're unlikely to have the same latitude and flexibility to act. A second preliminary comment is that it seems to me that the debate around cyber is driven too much by domestic authorizations and powers, and simply because of the huge capacity and weight and muscularity of the US position, it's driven too much internationally by the appreciation which informs a domestic debate around Title 10, Title 50, Title 6 First Amendment. And I know that Bobby's going to be talking about some aspects of this. The minute that you move beyond the shores of the US, the world looks very different, in particular in the UK. Now, of course, size matters, but nimbleness and flexibility also matters a great deal. And let me just very briefly read to you the authorization that is applicable in the UK domestic regime for our government communication headquarters, GCHQ, which is our principal cyber command, if you like. GCHQ has long been in existence. It's over 100 years old, but it was only declared publicly in 1994 through the Intelligence Services Act, which began in Section 3 by saying there shall continue to be a government communications headquarters. And then its functions were described in a very brief sentence, Section 3, paragraph 1A, which says that its functions are to monitor or interfere with electromagnetic, acoustic, or other emissions and any equipment producing such emissions, and to obtain and provide information derived from or related to such emissions or equipment and from encrypted material. So that's our legal framework. There is a broader statutory framework in terms of warrantry, but if you compare this to the legal framework applicable to US cyber operations, there is no comparison. And certainly from the perspective of a UK lawyer, one who used to wear a government hat, it's very interesting to compare that to your Title 10, Title 50, Title 6 First Amendment debate. Now, also, our GCHQ functions are exercisable by statute in three circumstances: in the interests of the national security of the United Kingdom, in the interests of the economic well-being of the United Kingdom, and in support of the prevention of serious crime. And there is no clear divide between military and non-military, between jus in bello and peacetime activity. There is no divide between external and internal, and there is much greater operational flexibility, even if GCHQ is considerably smaller than NSA and some of the other cyber operations that you have here. So this is a plea from outside of the US to say that actually the debate needs to be more informed by reference to international partners. Third preliminary comment is that I think we need to be very cautious about our sources of law in relation to cyber. There are very few that are directly applicable, even if there are some that are applicable indirectly because they apply to conduct more generally, whether it's the law in relation to sovereignty or elsewhere. But the plea is that we really need to subject our comments about sources to very critical scrutiny, to identifying whether there is state practice and opinio juris when we talk about customary international law. My inclination is that we ought to be rather cautious about being too affirmative of the lex lata, the law that actually exists. A fourth preliminary observation is that, at least in my view, we ought to have a real appreciation of one of the points that Jack Goldsmith made yesterday, but I'll put it in terms of the end of geography. And the end of geography is not so much supposed to be a Francis Fukuyama, the end of history development, but rather a Tom Friedman, the world is flat development. It seems to me that in the field of international law is still too deeply rooted in Westphalian notions of sovereignty and geography, whereas in fact the world has moved on. And I suppose this is where, if there is a space between what Wolff is saying and what I'm saying, he's talking about the lex lata. I'm saying that I think that there is a considerable uncertainty about the edges of the lex lata and that we need to look to the lex ferenda. And then my final preliminary observation is that I think that we can do better in helping to craft a more benign legal environment, whether it's around principles of deemed jurisdiction or lawful conduct or de minimis conduct or whatever. Now, moving then to, in essence, the sort of the meat of my observations, and that is that my view is that we should be slow to default to a jus in bello analysis. First of all, not all kinetic operations involving the military engage a jus in bello analysis, whether it's hostage rescue, UN operations against pirates, military action in support of police enforcement. We always have to ask ourselves, is this properly a conduct that is to be regulated by the jus in bello? And there are important reasons to be cautious about jumping to a jus in bello analysis. Firstly, it may not be appropriate to the circumstances. Secondly, if we jump to a jus in bello analysis, we might too quickly invite a kinetic response. Third, the jus in bello, the laws of armed conflict, may be rather too permissive. For example, in respect of targeting. If we immediately jump to a jus in bello analysis, all sorts of potential targets come lawfully into the frame. But the counterpart to that is that the jus in bello may also be too constraining. For example, in respect of countermeasures or in respect of the principle of distinction. If we are not in a jus in bello analysis, then activity directed against civilians may be more amenable to discussion. Additionally, the jus in bello analysis seems to me to presume that clandestine conduct, espionage, is regulated by law rather more fully than it is. Now, I'm not sure that I would go so far as to agree with everything that Eric Greenwald said yesterday, but I do agree with a good deal of it. And then finally, our caution about jumping to a jus in bello analysis seems to me to be influenced by an appreciation that it would otherwise expand and confuse the threshold for physical action. Now, that's not to say that a jus in bello analysis is not going to be appropriate in some circumstances, but let's not treat it as the presumptive default. Now, let me try and give one or two examples of coercive cyber activity as hypotheticals engaging the military that may not properly engage a jus in bello analysis. And I put this out there speculatively, not affirmatively. Let's hypothesize about a cyber attack emanating from a foreign state, possibly from its military civilian infrastructure, but a foreign state that is perhaps hostile to US interests, but not in a belligerent nexus, and that it targets the DoD computer system and removes 1 cent from every payroll. Now, is that to be analyzed through a jus in bello framework, perhaps inviting a kinetic response, or should it be conceived in other circumstances? What about UK cyber operations, possibly having kinetic effects against FARC cocaine laboratories in Colombia with the consent of the Colombian government? The fact that there is an internal armed conflict going on in Colombia, the fact that there are kinetic effects, does that automatically mean that we should be jumping to a jus in bello analysis? What about US cyber operations with potential kinetic effects against Afghan drug lords taking place within the geographic space of an ongoing armed conflict, but really focused on rather different objectives? What about cyber operations with coercive, possibly kinetic effects against Somali pirates? So the basic proposition is, let's inquire whether the jus in bello is appropriate rather than default to it. Now, I would suggest a number of elements of a jus in bello gateway analysis. These are not intended to be comprehensive, but a number. And let me just run through them quickly. The first, pretty straightforward, in fact, all are pretty straightforward. Is the cyber action equivalent to, or does it have consequential kinetic effects reaching a material threshold? And I think that's the traditional analysis that would be undertaken. Second, would the cyber action result in direct or consequential non-kinetic injury reaching a material threshold? You may have injury but not kinetic effects. Third, is the action in support of conventional military operations, or is it for other purposes? Fourth, is it intended to, or would it actually degrade the target state's military capabilities? Fifth, Would it cause large-scale and materially significant economic or similar damage? And again, and in respect of each of these five, I would add a further question, which is, would this activity pass a jus ad bellum gateway? Before we get to the in bello, we need to go through the ad bellum gateway. And then finally, as a question, I would ask, is the action undertaken by persons whose conduct is properly attributable to the state as a matter of law? I'm not sure that we should be jumping to a jus in bello analysis if we are faced with conduct by anonymous, the cyber organization, if you like. Now, just because we are not in a jus ad bellum and a jus in bellum territory, it doesn't mean, though, that that legal principles which are derived from those systems of law are not properly applicable, such as principles of proportionality and distinction. They may nevertheless be properly applicable. But I would put down a cautionary point here about the principle of necessity. It may be that the principle of necessity, particularly in its strategic dimension, would raise wider issues. Now, finally, let me conclude in the last 5 minutes or so that I've got with one or two observations about the wider international law framework and challenges. We've already heard quite a lot about the general international law, whether it's principles of sovereignty, jurisdiction, non-interference. A comment was made in the discussion yesterday that our cyber legal analysis or enterprise about the development of the law was akin to that around the emergence of the telegraph in the early 19th century. And I suppose my response to that is perhaps yes, in terms of the evolution of the technology, but no, in terms of the wider panoply of legal rules that are in existence. If we were looking at international law at the early 19th century, it would be a relatively blank page or empty page. When we look at the law now, it's relatively extensive. We've got specific rules and general rules that do apply to cyber. We've got a lot of regulation coming out of the International Telecommunications Union that addresses the electromagnetic space. We've got conventions that deal with cybercrime. When you have a look, for example, at the Israel-Palestine Declaration of Principles and Agreements, there are specific provisions that contemplate regulation of the electromagnetic sphere. So there is quite a lot of specific law out there. There is also quite a lot of general law out there dealing with sovereignty, territoriality, jurisdiction, non-intervention. The question in respect of those principles is, how does that law apply to cyberspace and the electromagnetic space? There are other principles of general law relating to diplomatic relations and immunities, for example. And then the last area of law that I'll simply reference and then conclude is the law in relation to state responsibility. Now, for those of you not necessarily familiar with the law in relation to state responsibility, this is a body of rules, largely codified, regarded by many, if not most, as customary international law, that deal with the system of international law. So they don't impose substantive rules, but deal with the system of international law and when international responsibility arises. And two aspects of those rules seem to me to be particularly important, and I'll identify briefly. One is that body of law dealing with attribution, and we've had quite a lot of discussion about attribution already. I don't propose to say too much about it, other than that the law in relation to attribution, which generally is pretty straightforward, conduct is attributable to a state if it's undertaken by state actors, seems to me to become immensely complex the minute that we begin to talk about shared operations, complex operations, operations under the command and control of the authorities of one state but undertaken by the actors of another state. And in the field of cyber, particularly where you have intelligence sharing, issues of attribution, not in terms of where the attack comes from, but how we organize our legal framework, those who perhaps may be responding, seem to me to be very considerable indeed, because we come from different legal frameworks. If you look at the US legal framework, both domestic and international law, it's very different from that of the United Kingdom, different again from that of Canada, from that of Australia, from that of New Zealand, and others. And then the final point, and I'll close with this, another principle on the law of the laws of state responsibility is that in respect of aiding and assisting or complicity. Given that we each come from different legal traditions, both international and domestic. But given that we are cooperating, both in terms of intelligence sharing, but also for purposes of using intelligence in support of military operations more widely, what can we properly do together without engaging questions of legal responsibility? I'll leave it there. Thank you.
Thank you very much, Sir Daniel. Our final speaker on this panel is Professor Bobby Chesney of the University of Texas School of Law. Bobby will discuss the Title 10, Title 50, and the international law in cyber warfare. Yesterday, Eric Greenwald referred to the Title 10, Title 50 debate, Title 10 being used at least colloquially to refer to the DoD and military operations, while again, at least colloquially, Title 50 refers to intelligence agencies, intelligence activities, and covert actions. Bobby indicates he's going to take us into the weeds on what this debate means in the context of computer network operations. Bobby?
Yes, I thought that what you guys needed first thing in the morning was to be taken into the weeds of Title 10, Title 50, so I hope you all had coffee. I'm mindful that Sir Daniel has just urged us to not dwell too much on the peculiarities and idiosyncrasies of the U.S. domestic arrangement, so naturally I will now do so at great length. I could just talk about Kevin Euclid being traded. That might be a different, no? All right. So I'm going to group my talk under three headings, three sets of issues or buckets of issues that the domestic legal arrangement for the U.S. raises in regards to cyber operations, at least some of the ones we could talk about. One of those buckets is information sharing, and by this I mean reporting to Congress, notification to Congress. And here the question is there a reporting obligation? But more specifically, how granular is that reporting obligation really, and which committees does it run to? And the big question here is, does the obligation run to the intelligence committees, HPSCI and SISI? Does it instead perhaps run to the Armed Services Committee, or does it not run at all? Second bucket of issues have to do with questions of affirmative authorization for a particular agency or department to carry out an operation. So one way to think about this issue is simply as a question of U.S. domestic constitutional law, separation of powers. Is the operation one that, for example, the executive branch has inherent constitutional authority to conduct? And if not, if it's something that instead requires some grant of statutory authorization, do you have that authorization given the nature of the operation that's contemplated and the agency involved? Third and last, I will talk about a topic that connects to the subject matter of our panel, which is, I suppose, the least I can do since Mike was nice enough to bring me here. And that is the question of whether the categorization of the operation for purposes of U.S. domestic law has an impact on, and I want to be precise in how I say this, has an impact from a domestic law perspective as to the agency or department's obligation to comport its operation with international law. The idea being that there might be arguments that certain operations are authorized domestically to be in violation of international law. Not that international law somehow itself exempts these operations, but rather that the U.S. government in some fashion can act with a statutory green light to violate international law. So let's talk first about information sharing in Congress. As Eric did mention yesterday, the domestic statutory architecture contains several buckets or categories into which a given operation may be slotted. For example, if the operation is categorized as covert action, certain things follow from this as a matter of statute. Most obviously, there must be, under Title 50, there must be reporting and relatively granular reporting and detailed reporting to the intelligence committees. And further, of course, the operation must be authorized by the President himself in the form of a written finding, or at least a memorandum of notification building on an existing finding. Now, there are several reasons why it might be particularly hard to make this kind of slotting decision. Is it a covert action? Is it not a covert action? It may be particularly hard to make that kind of slotting determination when it comes to cyber operations, though I want to emphasize it can be hard in general, whether we're talking about cyber or not. But there's things about cyber that might exacerbate this familiar definitional problem. And I'll group the problems in three different layers. The first layer is the fact that there is a disputed definition when it comes to the line between covert action and what Title 50 refers to as traditional military activity, or TMA. That's the acronym to use. I'm sure it's very familiar to many of you. Title 50 defines covert action as a default matter, as you heard yesterday, in paraphrasing, an activity by any U.S. government agency to influence events abroad where the role of the U.S. government is not meant to be apparent or acknowledged. Certainly computer network operations are quite possibly going to satisfy that definition. But of course, Title 50 contains exemptions to that definition. So there's the broad catch-all definition, and then you have a series of carve-outs, one of which is the TMA category, or traditional military activity. So the question arises, what counts as TMA? That's where the definitional issue arises. And the statutory text is silent on the point. TMA is not actually defined in Title 50 itself. And this seems to have led at least some to take the words at face value, which is an understandable enough approach when you don't have a statutory definition, and in particular to put a fair amount of weight on the word traditional, which is the only word besides military that seems to be doing any work in this phrase, TMA. And this in turn leads to an approach in which one looks for historical analogies to what the military has done in the past. And that's one place where cyber operations may get tricky, because depending on how much you're willing to analogize, you may or may not find it difficult to say that any given cyber operation is traditional. Now, here's the problem with all this. That's not how the definition is meant to work. The definition of TMA was the subject of years of negotiation between the White House and Congress. It went back and forth again and again over time. The definition they finally settled upon, which was enshrined in the conference report, not in the text, but only in the conference report, nonetheless is not an exercise in historical analogy, but rather an objective inquiry, which requires two conditions to be met, and they're both relatively easy to determine, at least from the inside, whether they're met. First of all, the operation must be commanded and conducted by military personnel. Secondly, assuming you have a complete chain of military command and execution involved, the operation must take place in a context in which one of two things is true. Either there's a context of overt hostilities going on in which the U.S. role is apparent and acknowledged, or even if you do not have overt hostilities, if hostilities are merely anticipated, this too can count as an appropriate context so long as operational planning for that potential future overt hostilities has been authorized by the national command authorities. Now, given those two tracks, TMA is actually quite broad. So to focus on that first track, overt hostilities, one need only think about the U.S. position that we are engaged in overt hostilities under color of the AUMF of 2001 against al-Qaeda, the Taliban, and associated forces. And you can appreciate the range of operations under that heading that would seem to implicate the TMA definition under the overt hostilities model. Of course, we all know that there's a great deal of boundary dispute about what the boundaries of hostilities with those entities may be. Organizationally, geographically, individually, on all these different dimensions, there's uncertainty, and thus uncertainty as to the boundaries of that aspect of the TMA definition. Separately, in setting aside the AUMF and the idea of U.S. hostilities with al-Qaeda and company, the alternative track in which TMA can come into play when you have authorized operational planning, well, of course, that's quite broad too. And while you'd have to be on the inside, I suppose, to know precisely which situations are ones in which operational planning has been authorized, you don't really have to be on the inside to appreciate that that probably encompasses a great deal of the situations in adversaries or potential adversaries as to which a cyber operation might be contemplated, whether we're talking about Iran, China, or terrorist organizations that somehow don't fit or do not fit within the al-Qaeda and associated forces rubric. In short, much of what you might, not everything, but much of what you might want to accomplish by way of an unacknowledged cyber operation, very well, if conducted and commanded through Cybercom, for example, seems to qualify as TMA. Now, does that mean that Congress would be shut out of the oversight process? No. We need to distinguish here between practice and policy on one hand and what's required to be done by statute. Certainly, as long as you're in the TMA category, there is no statutory obligation to report to Congress. But my understanding is that at least as a matter of policy, that the Armed Services Committee do get some amount of reporting on what is done by way of military cyber operations. And the question then becomes, is it granular enough? Is it, and that depends on what you think the level of granularity ought to be, which is a topic we could maybe discuss. Suffice to say that all you can really say is that some amount of reporting is going on. There's pending legislation, and there was an attempt last year to create legislation that would require it to be done as a matter of statute, sort of entrenching in statute what is already done. My understanding is that some think that it's highly granular. Other people have suggested to me it's not granular at all compared to what goes on with the intelligence oversight committees. And whether you're comforted or bothered by that depends on how much you think Congress ought to know. Now, that's just the first layer of complexity on information sharing with Congress. It gets complex as well for two additional reasons. First of all, the definitional dispute, though usually framed as a covert action versus TMA question, isn't just about covert action versus TMA. It's also about collection versus something else for which we don't have an acronym. Let me explain. The covert action model is the right one to bring to bear if we're talking about, say, Stuxnet, which is obviously influencing events abroad. But if we change our focus to, say, Flame or any other what appears to be an exploitation program, then things look a little bit different. We're not talking, if we consider it in isolation, about influencing events abroad. We're talking about intelligence collection. Now, as it happens, Title 50 contains an entirely separate congressional reporting requirement having to do with significant intelligence activities that certainly includes collection activities. And this is kept separate from covert action in part by a statutory exemption to the covert action definition that says if you've got an activity that has dual purpose, collection and influencing events, if the primary purpose is collection, and Eric mentioned this yesterday, you put it under the collection box. You don't have to have a written finding. You don't treat it as covert action. You treat it as collection. But there is reporting. And the thing is, there's not a carve-out for TMA-like military-commanded, military-controlled, hostilities-related collection activities. Title 50 is silent as to this, although you might well imagine that there could be a strong argument for having a TMA for collection, just like there's a TMA for covert action. Does that mean, therefore, that the military is reporting even every last narrowly tactical, high-volume, battle zone-related collection-type activity that's going on? It's very hard to comment on this from the outside. My understanding is that this has actually been a bone of contention in practice over time that's not necessarily ever boiled over, but that it's certainly not the case that every last little thing does get reported. And as a matter of practice, the committees have lived with that. The interesting question is, as cyber operations become a bigger and bigger deal, will this become a bone of contention that does have to be addressed? Will it have to be revisited by statute? Does there need to be a TMA created for military collection activities, at least in the context of hostilities? Finally, the last layer of complexity on the information sharing issue has to do with the fact that it's not so easy to say exactly what the unit of analysis ought to be. And here again, the public reporting on Olympic Games is very useful, at least from an academic perspective, to give us fact patterns to work with we can sink our teeth into. Is it proper to look at Flame alone, assuming what's been reported about it is accurate? Is it proper to think of it as a standalone program that, if examined in isolation, probably looks like collection or exploitation, not covert action? Or should you look at it as part of an integrated set of code along with Stuxnet and have to come to grips with the more difficult question of collection versus impacting the environment? It's not obvious, and certainly Title 50 doesn't tell you how to look at various streams of code and to decide how to chop up the block that then gets analyzed for the primary purpose test. And we might add, as I think someone mentioned yesterday, you don't always know, even if you know your unit of code you're looking at to conduct this analysis, even if you've decided how you're going to do that, you don't necessarily know on day one what the right categorization is going to be, for so much code could be dual purpose. It certainly could be, the same lines of code could be the central feature of an operation that later on will affect events, but right now it's just being used to collect information or to map the system. And it's very hard to say, I think, in cyber context, how this all works with respect to the domestic framework. Now, turning to my last two buckets more quickly, the first one is affirmative authorization to act under our U.S. domestic law. And here again, the question is whether the nature of the operation is such that the executive branch would have a perfectly plausible Article 2 constitutional argument, as Mark mentioned yesterday in some context, or if instead maybe there's a statutory foundation for the action, and might this impact who can do what. Suffice to say that if we're talking about operations that are no more than collection operations, I don't think this is a terribly important question. I think that there are all sorts of good constitutional and statutory arguments that more or less cover the bases. If we move beyond collection to efforts that will influence events abroad, and we're speaking of CIA and Title 50 covert action, again, I don't think we have much of an issue because, after all, Title 50 at this point is quite clear on this. The agency has standing authority to do this. Doesn't need an AUMF, doesn't need other things to engage in covert operation. There's the blanket authorization itself. But if we're talking about TMA, if we're talking about a wholly military activity, there is some uncertainty that can arise here. On one hand, the military doesn't have a standing blank check to engage in TMA in the way that CIA has the standing authority to engage in covert action. You need to look to particular authorities, and of course we talked some about the 2001 AUMF. That raises some questions but authorizes something. There are arguments that Mark mentioned yesterday about inherent constitutional authority relating to self-defense of the nation, unit self-defense or self-defense arguments that can be made in terms of our systems themselves. And all of these are obviously contested concepts on their margins, all the more so when we move to the realm of active self-defense, as Stuart was talking about yesterday, or what we were previously talking about in terms of anticipatory self-defense. And then we might add in, with reference to Libya, the possibility of constitutional arguments about inherent executive authority to do things that don't rise to the level of intensity and so forth that we associate with outright war. And as we know from the Libya example, that was a highly controversial set of claims, and it has interesting implications for what the military can do here. Jumping ahead now to my last topic, and let me just add, if you're wondering whether this is really an issue worth talking about, I will simply point to the fact that Congress, both last year in the NDAA for fiscal 2012 and in this year's pending NDAA legislation, has put forward and fought over language that in very murky and not obviously helpful ways tries to clarify the authority to engage in offensive operations in third countries for the military in the realm of cyberspace. And we can talk about that in the Q&A. Let me close by talking about the intersection here with international law compliance. Simply put, the question is whether our domestic statutory framework gives the executive branch in some capacities what amounts to a green light to authorize operations that would put the country in violation of international law. And very specifically, is this the right reading of Title 50 covert action? And is it different than for purely military action that would constitute TMA, such that you end up with a situation where the CIA can be asked to do things to violate international law in a way that is, at least as a statutory matter, more easy to authorize than it would be to direct the military to do so. Why would anyone think that this is the case? Well, I direct your attention to 50 U.S. Code Section 413B, sub A, sub 5, which is the last in a series of things that are stated by Congress with respect to a covert action finding, what it can and can't do. And it provides that a covert action, quote, finding may not authorize any action that would violate the Constitution or any statute of the United States, period, full stop. Constitution, statutes, not treaty, not customary law, and so forth. No mention of international law of any kind. Some have argued, some have suggested that this should be understood as a quiet way of conferring explicit, is that possible to say? A quiet way of conferring explicit, of implying, but strongly implying, statutory authorization for findings to authorize covert action to violate international law, non-intervention principles, or what have you, when conducting covert action. Now, is this something that the agency talks about in public? No, of course not, except when maybe it kind of does. The general counsel of the agency gave a talk at Harvard Law not long ago in which, in the published remarks, he very starkly contrasted the clear and legally binding nature to comply with the Constitution of the United States, and then gave separate remarks about the agency's operations being conducted compatibly with principles of international law. And many observers who read those remarks said, well, that sure sounds like an expression of what I was just talking about, the interpretation of the statute. It's interesting to note that in the non-published Q&A at that event, my understanding is that there was a very explicit question offered from the audience on this exact point, and that the answer was to endorse the reading I just gave you, that the statute requires compliance only with the purely domestic instruments of the Constitution and statutes, not international law. So I will leave there because I've already, I think, gone over my time a little bit, but I look forward to the Q&A.
So the Cadwalader hook has arrived, so please join me in thanking our panelists.